Hi, I'm Traven Govender. I'm a retirement benefit counsellor at Momentum Funds at Work. I've been in the financial services industry for over 16 years, winning numerous accolades along the way. Today I'm here with Tebatso Moloko. Hi Tebatso.
Hi Traven, how are you?
Good, thank you, Nisal.
Good day everyone, my name is Tebatso Moloko and I'm a fiduciary business development consultant at Momentum Trust, and I am also an admitted attorney, being in the fiduciary industry since 2015.
Perfect. Today we're going to have a conversation around wills. But before we even start, I came across something interesting. According to reports, a large percentage of South African working population do not have a will in place. And we conducted a poll on our LinkedIn page about a week or so back. And it indicated that majority of the respondents were not entirely confident with their current understanding of wills. In this session, we'll address some commonly asked questions regarding wills and estate planning.
100%.
One of the very first questions you're going to come across, and I'm sure you've heard this numerous times: what is a will and why do I need it?
Thank you very much, Traven. You actually touched on a very important topic that actually affects our country as a whole. So it was actually estimated by the Master of the High Court that 70% of working South Africans do not have a valid will in place. And unfortunately, this is not even unique to South Africa, because 68% of US citizens who should be having wills actually do not have valid wills in place. And it's not even unique to the normal people. In actual fact, famous celebrities that actually passed away without having a valid will in place. I mean, you can think of your Aretha Franklin, your Prince, your Amy Winehouse. The list is endless.
And we went out to one of our funds at work clients, and there was a member that was there.
Yeah.
And we went to do beneficiary nominations, and she was like, I'll only do a beneficiary nomination after I've completed a will. But then we had to highlight the importance of doing both, because you need to have beneficiary nomination, but on the same side you need to have your will completed. And the very next question is, what happens if I die without a will?
That is a nightmare in any situation, because if you die without a will, it means then the law will decide how your estate is to be distributed. And unfortunately, in that case, you might have unintended recipients actually receiving from your estate. I can give you practical examples. Let's say you are married. If you're married, everything can go to your spouse if you survive by your spouse only. If you are survived by your parents and you're not married and you don't have any children, unfortunately, then your estate would be divided into half. Half would go to your father, half would go to your mother. Again, this is regardless of whether you've got a relationship with either of the parents. Unfortunately, then interstate succession will decide for you. It gets even worse. Here's another example. If you are survived by one parent, we can assume your mother in this case, and your father has passed away. Again, your estate would be divided into half. Half would go to your surviving parents, in this case your mother. The other half would be distributed evenly amongst all your father's descendants. In other words, all your father's children, including those children you didn't even know existed. They stand to benefit from your estate.
That sounds like a horrible
That's
situation
a terrible
to be
situation.
in. Yeah. So Tebatso, you brought up all these important scenarios that could happen, and it's not even scenarios, these are real life incidents that happens, because you deal with it on a daily basis.
Yes.
But then, following up to what you just said to me, what makes a will valid?
Very important. So remember, you can actually document your wishes on a piece of paper, but if it's not in line with the Wills Act, then it's not a valid will in itself. So it's very, very important that you get a professional to assist you. Now, there are certain prescribed formalities that declare a will valid. Number one, a will needs to be drafted by a testator. So a testator in this case would be a male, testatrix would be female. Obviously they would need to be at least 16 years and older, and they need to sign the will, or if they want someone else to sign the will on their behalf, then they can do so at their instruction. But it's very important that a commissioner of oath commissions that will to satisfy themselves as to the identity of the testator. The will is generally signed at the end of every page if there is more than one page. And obviously then they must be two competent witnesses who are at least 14 years and older and able to give evidence in a court of law. Very, very important. These witnesses need to sign in the presence of each other and in the presence of the testator. So very, very important. You can't have one witness in Durban and another one in Johannesburg. They need to be at the same time, at the same place, together with the testator when witnessing the will. Another very important aspect is if the testator chooses to use a mark instead of a signature, it is also important that a commissioner of oath actually commissions that will to satisfy themselves as to the identity of the testator. So I'm using testator just to avoid tongue twisters.
Perfect.
Yeah.
And then following up, you emphasize quite a lot on witness.
Yes.
What makes, who can witness a will?
So it needs to be someone that's at least 14 years and older and able to give evidence in a court of law. By the way, you can't have any of your beneficiaries actually witnessing the will, because if they do witness that will, they will be automatically disqualified from inheriting from your estate.
So Tebatso, earlier you mentioned quite a few things,
Yes.
Having a valid will, what's a will, valid witness, all those type of things.
Yes.
But now, very importantly, how often should you review a will?
We strongly advise that you review a will as many times as you possibly can, but generally recommend that you review it annually or biannually, depending on your circumstances. If you're someone that obviously have particular changes, then it's recommended that you obviously change it as often as you can.
Okay, so my follow-up question to what you actually said now, and this would be very important to so many people. In what instances should a person review the will?
Generally, if there's a change in your marital status, if you have a new member of the family, if you adopt a new child, if you acquire new property, if there's a change in your marital status, then you can definitely change it. There are many, many other examples you can add from that. If you want to appoint a new executor, if there's a death in the family, if one of your beneficiaries has predeceased you, in other words, died before you, you can obviously then make those changes.
So it's very important for our members, right?
100%.
One of the key things about having a will with momentum trust and wills is that you guys appoint an executor.
Yes.
And it just makes the whole process so much more smoother.
100%. So in actual fact, Momentum Trust can be the appointed executors if you do choose us. So a nominee of Momentum Trust would be the executor. Alternatively, you can choose anybody else that you do trust to become the executor. But it's important that when you choose an executor, it's someone that actually specializes in winding up estates and is a fiduciary specialist.
Thank you, Tebatso, for all those answers that you've given me thus far. But, going back a little bit. So if you're married,
Yes.
Can you and your spouse have a joint will?
Yes, you can actually have a joint will, but a joint will is generally made if both spouses actually intend on leaving or bequeathing the entire estates to the remaining spouse. So you can actually have a joint will if you want to, but there are disadvantages of joint wills, and generally in the industry we don't advise for joint wills because of the many disadvantages, because it's one single will that is generally lodged at the master of the High Court on the death of the first dying spouse. So there are many disadvantages, but there's obviously nothing wrong in having a joint will, so spouses can actually have a joint will for each other.
Okay, so as you said, it's nice to have a joint will, but also there is the disadvantages of having one.
Yeah.
Perfect. And then following up to that, right, having a joint will
Yes.
and a single will is obviously making things easier for your family when you're not there.
Definitely.
However, do you need a professional to help you draft a will?
The reality is you can actually take a piece of paper and jot down your wishes. The problem with that is you do not have the technical knowledge of what a valid will should look like in terms of the Wills Act. So it's strongly advised that you get a professional to assist you in drafting a will that will speak to your unique circumstances, that will speak to your own financial plan, so that it is an executable will. So it's very, very important that you rather get a professional, because through a will, you will be able to have an active estate plan that speaks to your financial plan.
So Tebatso, going back to our earlier conversation, right,
Yes.
where I gave you that example of the member that we went and saw at our Funds at Work member,
Yes.
who wanted to complete a will without choosing a beneficiary.
Yes.
Some people may confuse a will and a beneficiary nomination.
Yes.
Can you just clarify what is the difference?
Very, very important. So at Momentum, we actually put together a 4-bucket asset framework, and this is a framework that helps us to distinguish between the different types of estates. So a will is very critical, but what does it cover? So we've got these 4 buckets. First bucket would be your personal estate. Second bucket would be your deemed estate. Third bucket would be like your retirement, your provident fund, you know, those type of things. And the last bucket would be your trust estate. So your will cover everything that's within the first bucket, which is your personal estate. So what do I mean by personal estate? I'm talking about claims in favor of the estate, like money in the bank, your investments, and so forth. I'm talking about immovable property like your house. I'm talking about your movable property like your cars, furniture, and so forth. All of these form part of the first bucket, and in your will you are able to deal with all of these things. The second bucket would be your life policies that actually have nominated beneficiaries. Remember, these are separate from your personal estate. The moment you pass away, this will be paid directly to those nominated beneficiaries, and it does not go to your personal estate. So that's why it's important for us to distinguish between nominating beneficiaries and having a will to receive certain bequests. So a will obviously cover those 3 aspects that I've basically mentioned: your movable property, immovable property, claims in favor of your estate. And with every other thing, your pension funds, you need to nominate beneficiaries for those, and so forth. So very, very important for us to distinguish between the 2 aspects.
So that's the whole idea of as to how they work hand in hand together.
100%.
And they cover each other.
100%.
Perfect. Now, South Africa is a diverse country, right?
Yes.
And we have different types of marital
Yes.
regimes here in South Africa.
Yes.
One of the key things is because, you know, as I said, there's so many people that's married differently.
Yes.
Okay? How would that impact your will, or in what way and how?
Very, very important question. So there are various matrimonial regimes. I'll just refer to the main ones. So there's obviously customary marriage. So a customary marriage, you know that you are automatically in community of property. We've got marriage in community of property, so a civil union in community of property. And we've got marriage out of community of property with a crew. And we've got marriage out of community of property without a crew. So it's very, very important for us to be able to distinguish between these various types of marriages. Now, assuming you are married in community of property, when coming to your will, you can have a separate will from that of your spouse. However, it's important that you say, I am leaving my 50% interest in my house to so-and-so. So you can't say I'm leaving my house to so-and-so, because you only have a 50% interest on virtue of your marriage in community of property. So that's just one example I can give you.
So Tebatso, we've been having this conversation, right?
Yes.
And I don't think I asked you a question such as this, so I don't think you get this often.
Yeah.
But tell me, what are the reasons you will hear for people not having a will?
These are reasons that we get out there in the market, and I refer to those as lame reasons because a lot of people, number one, don't want to discuss their own mortality. They believe if they start talking about wills, they're inviting death or a dark cloud over their lives. Very lame in my understanding. Secondly, they think it's too expensive. The reality is it's not. We having Wills Week coming up, and throughout the fiduciary industry, attorneys, trust companies will be giving out wills for free. At Momentum Trust, we give out wills for free all year round, all day, every day. Obviously, there are conditions. You need to have a financial advisor, and the financial advisor would need to create a profile under their profile using our systems. The other way is if you can actually go to our corporate website where you can make use of our client direct system, where you can actually draft your own will on the client direct system by simply completing a questionnaire, clicking submit, and it will populate a free will for yourself. The other way is if you get a product called the Estate Provider Benefit product, which comes with a free will. It's actually a product that's put in place to ensure that should you pass away, administrative expenses are covered and so forth. Other reasons that people give, they believe it's for the professional to do it. Like I've already mentioned, you can actually draft your own will, but if you're not familiar with the prescribed formalities, it's a bit dangerous because it's a will that might not be executable. Procrastination is another reason. I will do it tomorrow. What if tomorrow never comes? So remember, tomorrow is a gift, not a promise.
So essentially what you're saying to the members is there is no excuse.
100%.
Perfect. Now, very importantly, right, as I said, we're speaking to a lot of our funds at work members. Many of them do not understand financial services industry in depth,
Yes.
but they would like to have their finances in order. Everybody would want that.
Yes.
Right? But one of the key things is, what is estate planning?
Estate planning. So, there are many definitions of estate planning, but they somewhat explain the same thing. One definition would be the arrangement of a legal and administrative process to ensure that your interests and those you care for are protected during your lifetime and after your death. So essentially, it's obviously during your lifetime, you trying to gather as much productive assets as you can so that you're able to maintain your lifetime all the way through retirement and even after death. So through a will, you have estate planning. So you've got a financial plan through the aid of a financial advisor. Then you have a fiduciary specialist actually assisting you to draft a will that will obviously ensure that with that financial plan, you've got an estate plan that speaks to your financial plan, thereby transferring your legacy to the future generations to come.
So your estate planning and wills form a big part of each other.
100%, and they need to speak to each other.
So Tebatso, I've made your job very easy so far. I've asked you simple questions, but now I'm going to test your knowledge of it.
Yes.
One of the questions that I don't think you get this asked very often, but what is freedom of testation?
Very good question. So freedom of testation basically means you can bequeath whatever you want to whoever you want as long as it's not contra bonus morals. So contra bonus morals is Latin for contrary to good morals. So you can give whatever you want to whoever you want as long as it's not contrary to the law, as long as it's not illegal, immoral, or vague or against the law. You've got that freedom of testation to give whatever you want to whoever you want. However, there are limitations to this freedom of testation. So you need to take into account the type of marriage you've entered into, whether you've got minor children that you've been maintaining. So obviously you can leave your spouse out of your will and say, I'm giving everything to so-and-so. However, your spouse can still have a maintenance claim against your estate in terms of the Maintenance of Surviving Spouses Act. And same applies to minor children that you may have. They can also have a maintenance claim against your estate. Also taking into account contracts that you may have entered into, that also has an impact on that freedom of testation, including agreements that your beneficiaries might enter into after you have passed away, which obviously go against your testation, in other words, against your will. So there are certain limitations to that freedom of testation, but the law does allow you to bequeath whatever you want to whoever you want.
So very important on the last statement you made, right?
Yes.
Bequeath whatever you want to whoever. However, can minor children inherit in their own personal capacity?
Very important question. Unfortunately not. So minor children cannot inherit in their own personal capacity because they obviously can't manage their own financial affairs and so forth. So it's important that when you're having a will set up, that you make provision in your will for the creation of a testamentary trust. So a testamentary trust is a trust that is set up after you have passed away because you've made provision for it in your will. And the purpose of that is so that whatever would have gone to your child is held in this trust. And there are obviously various options that you can choose from. You can either say you want the trust to terminate when the child turns 18. I don't think an 18-year-old is responsible enough to handle their financial affairs. You can even opt for an older age of maybe 25, 26 when they're done with varsity. Or you can even opt for partial releases of the trust capital at specific ages where you can possibly say 30% at age 21, the remaining balance at age 26 or 27, however comfortable you are with your child and how you obviously view that. And so very important.
But I actually like that. I mean, there's so much of flexibility.
Yes.
For minors, because many of our members would have minor children.
Yes.
And the flexibility is there for them to actually ensure that the minor children are not left out and because they can't take care of their financial well-being.
Exactly.
So it's really, really nice to have that will in place.
And the other thing, by the way, before I forget this, you can choose to give it to the guardian of the child. But remember, the guardian of the child might not use it for the benefit of the child. So putting it in a testamentary trust makes it even safer, because you've got professional trustees that will handle the trust, run the trust until such time where you choose it should be terminated.
Okay, Tebatso, so now you've answered a lot of our questions.
Yes.
But now, I told you this part of the conversation where I'm testing on you.
Okay.
So now, very importantly, what is the impact of a divorce or an annulment in your marriage on your will?
Very, very important, Traven. So Section 2B of the Wills Act basically says that if you get divorced, so just to put it in simple terms, the moment you get your decree of divorce, you change your will immediately. However, you've got 3 months to change your will. If this 3 months lapses and you happen to die and still have not changed your will, unfortunately, your former spouse will inherit from your estate. However, if you die within this 3 months, although there's nothing fortunate about dying within 3 months, then it would be deemed as though you were never married, and your former spouse will be excluded from inheriting from your estate. So you either wish you die within the 3 months or you change your will immediately. Entirely up to you.
No, I'll change my will. And then this is your toughest question.
Yes.
Can a disabled person without hands or a blind person execute a will?
The answer to that is yes. So if I'm disabled without arms, I can actually still have a will. I can actually ask you to sign my will on my behalf. So I give you the instruction to sign my will on my behalf. However, it's important that a commissioner of oath commissions that will to satisfy themselves as to my identity as the testator. So it's very, very important to avoid future litigation or someone disputing the validity of the will because I do not have arms. So a commissioner of will will need to obviously commission that will. Same applies to a blind person. I can use my thumbprint to obviously get that will signed. Again, a commissioner of oath would need to commission that will to satisfy themselves as to the identity of the testator.
Thank you, Tebatso. You know what? You've given us so much of information. I mean, you've clarified so many things, you know. Yes. Being in the industry for so long, I mean, I've got so much more insight on wills and how it operates. I really appreciate, you know, all the information you've shared on us. And for the members, I mean, I'm sure your department's going to be inundated with phone calls and emails because, I mean, so many of them now will understand why it's so important to have a will in place. And for me, what I actually like about this whole thing is that it covers everybody. It doesn't leave anybody out in your will. Even right until your minor children are covered. And you know, we're leaving a legacy with the will.
100%. So it's important. We do want to be inundated with wills because we're trying to get everyone to have a will so that they avoid interstate succession. So it's very, very important that everyone, so we need to fight against the stats that 70% do not have wills. So we need to get everyone to have a valid will in place. So it's very, very important.
I'm sure after this conversation, your stats will drop quite drastically.
Definitely.
Thank you so much for your time. It's been a pleasure talking to you.
Only a pleasure.
Thank you, Tebatso.